Okay. All right. Thank you very much. Okay. So welcome everyone. And thank you very much for joining us for our next meeting of the Senior Fraud Task Force. Once again, we have a very full agenda, but I'm looking forward to this discussion and continuing in our work. I just wanted to take a quick moment to address our last meeting and just think about kind of our work going forward. Some members and others expressed some concern about guest speakers asking questions of other guests, and in part it has to do with the task force structure. So my apologies to the members and our guests from last week, but Joan and I have agreed that we are not going to be singling out any companies or anything having to do with any pending litigation. And but we want to welcome everyone here, and just but to be clear though, to our friends who may be new to the Connecticut General Assembly and its decorum and comportment, it's important to note that this isn't a jury room or a courtroom or a deposition room or a place for a third bite at the apple. This is a place to kind of explore great new concepts. And what I'm really excited about as we reflect is we've heard from Marie talking about kind of the need for um, our elderly and frail populations in particular needing assistance in gathering documents. We've heard that. That's something that's kind of uh, uh, opened up, I think, in this marketplace, kind of the rise of the type of services that we're going to be looking at. But I think also we're going to have some great new recommendations to bring forward to the legislature. Jackie brought up language accessibility. Our guest last week, Amy Tedesco, brought up some great recommendations about disclosures that should occur in relationships with different facilities. Joan has a really wonderful idea regarding checklists, and we want to really work on that. Steve mentioned before the importance of visual learning and video resources. And it's really going to be up to us to kind of like explore this concept of fraud. What does it mean still? Is it if folks pay money for services but then get denied, or are they getting their services still, and other issues that may arise from it? So what's exciting is that we all share the same goals for really good outcomes. And so let's continue with our good work and our goodwill as we develop concepts for a great report to submit to the legislature, and really working to help address as we discussed, our exploding aging population, our rebalancing efforts, and all of the issues that help to address Connecticut's seniors. So thank you very much, and I'm looking forward to this robust discussion. Thank you, Joan.
Thanks, Michael. And thank you, everybody. I hope everybody had a happy Thanksgiving. As Michael mentioned, we did talk about the last meeting. Joe and Michael and I had a meeting yesterday to kind of, make sure that going forward, we really focus on what the intent of this task force is, which, like he said, we all agree that it's really meant to make sure that we're figuring out what the issues are with the seniors, and coming up with a good report that we can present, so that any holes in the systems where we see people are being harmed, not necessarily physically harmed, but financially harmed, can be addressed. And today we have 3 more DSS representatives, and we have 3 attorneys, one of whom is from another state. So he's going to come and explain to us, what they're doing in their state and what's worked and what hasn't, so we can try to formulate a report that will address and adequately protect the consumer, hopefully going forward. Because even though there are provisions in place, there are still lots of holes in the system. So hopefully we can figure out what those are and move forward and come up with a good report. So I think today we're starting with the DSS representatives. I don't know, Matthew, if you want to introduce them or if they just want to jump in, but I'll let you take over at this point if you want to introduce.
Sure. As DSS, we come as a team. So today and this morning, I think it's very helpful. We've got three fantastic representatives from DSS, exceptionally knowledgeable. Peter Hadler, the director of the program services and grants unit, Kristen Dowdy, manager and co-lead with that unit, and Sarah Chmielewski, who spoke last time, are here to one, be a resource and answer questions regarding the long-term services and support application process and determination process. And I believe, and I apologize, Joe, it came over a little bit late yesterday. Sarah's prepared to go through a short walkthrough of a PowerPoint and some other materials, just walking through that process. But I'll leave Peter, Kristen, and Sarah, if they want to formally reintroduce themselves to the task force and say a couple of words before perhaps walking through those slides and then being available for any other questions.
Thank you. I wanted to mention one thing I forgot to mention earlier. We do have one of our guests has to leave early. So if we're running out of time, we will interrupt and then maybe go back for questions. So it just depends on how long everything's going to go. So I just wanted to let everybody know that at 10:30, we're going to be trying to move on to a speaker who has to leave at 11.
So Peter, would you want to introduce yourself?
Sure. Hi, everybody. My name is Peter Hadler. I'm the Director of Program Oversight and Grant Administration here at DSS. In this role, I still oversee eligibility for a variety of the DSS programs, including Medicaid and Husky, as well as SNAP, cash assistance, and energy assistance, among other programs. So I'm happy to be here to hear from, hear your questions and get a sense of what you guys are looking to discuss through this channel, and also to be able to support the team as much as possible. Kristen Dowdy, I can turn it over to her. She's our medical eligibility unit manager, and of course Sarah as well, who I'll let her introduce herself too. But Kristen, you want to go next?
Sure thing. Good morning, everyone. Again, I'm Kristen Dowdy. I'm the manager in the medical eligibility policy unit as part of the department, or division rather, of program oversight and grant administration, as Peter mentioned. And I'm happy to introduce you also to Sarah Chmielewski of my team, who is a subject matter expert in long-term services and supports, and who will be walking through our presentation this morning. Sarah.
Thank you, Kristen. Good morning, everyone. So I do believe you all received the slide deck. I'm not sure if you want me to share my screen or just use it as a guide to go through.
Yes, sir. You wouldn't mind sharing your screen when you present that.
Okay. I haven't done that on Zoom, but I can figure it out. Can everybody see that?
No. Screen share screen. There we go. Thank you. It's working now.
All right, great. So the process surrounding these applications is mostly manual, taking place outside of the department's eligibility system. We first ask that a completed W-1 LTC form is mailed to the correct DSS office. The 3 offices that handle applications for care in a facility are Waterbury, Bridgeport, and New Haven, and the Greater Hartford office handles those for home care services. Online applications are also accepted, but are not as extensive, which most times requires more follow-up and a lengthy request for additional information. Applications cannot be accepted via fax or email due to the volume of supporting documentation that we often require. The requests for additional information, known as a W-1348 form, proofs we need. You may also hear VCL, which is a verification checklist. We aim for issuing these within 15 days of application receipt. They list the assigned staff member's contact information, their name, email, and direct phone number. And it also includes the documents needed to determine eligibility. This slide here is a list of the application centers and which towns they serve. The towns listed here are where the facility is located.
Larger, just so it's full screen.
Okay.
It's under slideshow review, I believe. In the top.
Sorry if this thing is.
No worries. Yeah, in the top, in the tabs.
Yeah, I know my screen is.
If it's too hard, it's no worries. I'm going to send the slides to everyone so they have them as well.
Is that any better? Okay, eligibility determinations. In order to be eligible for nursing home care or home care services, you must be a US citizen or an eligible non-citizen, be a Connecticut resident, have a limited amount of income and assets, and require the level of care provided in a nursing home, whether you are living at home or in a facility. LTSS applications are assigned to a staff member who handles it through grant or denial. And once assigned, clients and authorized representatives should work directly with that individual. It is best to disclose all information up front to prevent application delays. We recommend submitting a valid W-298 form if you want to assist with the application and receive copies of the notices. This is how you can become an authorized representative on file with DSS. Facilities are responsible for updating the assessment pro system with the date of admission and level of care. DSS cannot grant coverage without this information. As previously stated, an authorized representative may be designated to act on an individual's behalf via a W-298 form. An AREP can be an individual or an organization who is knowledgeable about the individual's circumstances. These 298 forms can be submitted with the initial application or any time thereafter, and they can be accepted via mail or online, where they can be accessed by any DSS staff through our computer systems. Income and assets. Some examples of income that are reviewed by DSS staff are wages, Social Security benefits, pensions, veterans benefits, dividends, and interest. Some examples of assets are bank accounts, stocks, bonds, trusts, annuities, crowdfunding accounts, property, and life insurance. DSS does follow federal and state laws about how much income and assets you can have and still be eligible. Treatment of assets is described more in detail in the other document that was provided to you, the 1659 form. It is a 6-page document and it contains common questions and answers surrounding long-term services and supports. Patient liability, or PLA, is the amount that a beneficiary must contribute towards the cost of their care. Contribution begins once someone is in the nursing facility for 30 consecutive days. And if receiving home care, it starts the month that eligibility for services begins. PLA is determined using the total gross income less the total allowable deductions. In February 2020, DSS began using an electronic asset verification system, or AVS, to help streamline the review of assets of our aged, blind, and disabled populations, including those seeking long-term care. This system only provides us with assets that are held in financial institutions, and it's only the balances as of the first day of the month. It does not allow us to see individual transactions. DSS responded to the COVID-19 public health emergency by maintaining eligibility for most individuals, even if they were otherwise ineligible. We have a couple resources here for you, which are links to our public website, where you can read more about DSS's COVID response. And that concludes the presentation. Thank you.
Thank you, Sarah. That was helpful. Did you want to say anything else, or does anybody else from DSS have anything else they want to present, or is there any member that has a question? Matt has his hand up.
Well, thanks so much, Joan. Is that the end of the DSS presentation?
That is what we have today, Matt.
Sure.
I just
Okay,
also
no,
want to let you know that we did attach an additional form, which is helpful, I think, for people to be able to get a little bit more detailed understanding of some of the LTSS processes. It is something that we publish and circulate to applicants and clients. So you may find that useful. It's you may, folks on this task force may know more about it, but it's sort of a high level view of income and assets and some of the other questions that are typically asked by people. So that's just a sort of a resource. We're not planning to walk through it right now, but we thought it would be a useful reference tool.
No, hey, thank you so much, Peter. And thank you to the chairs for inviting DSS. I think it might have been an early suggestion that I made. And I really appreciate Peter coming, as well as Kristen and seeing Sarah again. I do have a couple of questions, just because I kind of want to get them onto the resource page or the task force record. And the first is, can you talk a little bit about the standard of promptness that is required by federal law in terms of application timelines for long-term services and support Medicaid applications? And I'm not looking for a dissertation, but just the 90 or 45-day rules that apply concerning that.
Sure, I'm happy to give us a shot at that one.
Jump in for 1 second, Peter. I think
Yeah,
we
go
had
ahead.
talked about the last meeting that the promptness of DSS and the application process is not necessarily what the focus of this task force is. I'm happy to have him answer that if that's of interest to everybody in the task force, but I don't want to spend too much time on that because that's not really what our mission is. It doesn't go to fraud. Obviously, there's issues related to timing, but I don't know that it's necessarily what our task is on the task force.
Okay, I can skip that. I believe it's relevant on the issue of why third parties have emerged in Connecticut to do application assistance work, but we can move right over that. That's fine, Joan. Can DSS talk about the qualifications of the persons that process eligibility determined applications? I believe they're still referred to as eligibility services technicians or eligibility services workers. And again, just briefly, what are their qualifications?
So I can start, but I'm not sure if I've got the full job specs thing in front of me. I'd be happy to circulate those if that would be useful. We do have eligibility services workers and eligibility services specialists who are working on processing these applications, as well as supervisors of units comprised of those eligibility service workers and specialists, and also, of course, managers in specific areas related to long-term care within each of our application and renewal hub offices, as well as our community options division, which assists with home care applications for services. So I'm happy to circulate those job specs if you'd be interested in seeing them. They generally require a college degree and a level of experience. Our LTSS staff are generally some of the more experienced staff in the agency. Just wanted to, I'll note that.
And I also think, Peter, that there may be a social services trainee avenue where you can become an eligibility services worker without actually having to have a 4-year degree. But be that as it may, this task force has discussed a really complicated Medicaid eligibility determination process and the rules that oftentimes give rise to the need and recommendation to seek legal assistance. Is it the department's, is it federal law Or is it the Department of Social Services view that Medicaid applicants must require the assistance of an attorney in the eligibility determination process for long-term care services and supports?
No, people should be able to apply on their own in large part. I mean, sometimes there are people who have got more complex situations or for reasons of, incapacity or inability to sort of complete applications on their own, they require assistance, but that can be a family member or another member, person, or a facility, for example, if they've already gone into a nursing home, the facility can facilitate. I don't believe the applications need to be submitted or supported by attorneys.
Right, and for the most part, almost exclusively, DSS employees that review the applications, would you agree, are not attorneys?
Yeah, absolutely. We do have
Right.
attorneys who support with more complex instruments and questions that relate, for example, to complicated trusts or annuity structures. But for the most part, no, there are not attorneys processing these cases.
Right, and so just stated a different way, your DSS's interpretation of federal law or DSS's view is that the application process is not so complicated where an attorney must be used to complete it. I mean, and the public materials you post and you provided links to, they don't advise consumers in that regard either.
Well, I don't, I'll speak for the group on that. And I don't think the agency really takes, I mean, obviously, federal law, there's certainly no requirement that attorneys assist in eligibility and the application process for long-term services and supports. But every individual has the right to make a determination as to what best fits their circumstance, and if the assistance, certainly with agreements or that would, if to be prepared for compensation, would be, engaging in the practice of law. I mean, that certainly would be for that individual to determine best with their own financial and overall circumstance. But the agency, whether the assistance of counsel, speaking as attorney, attorneys can be of great help, especially if you specialize in a certain area of the law. But the agency doesn't take any position either way, aside to say that certainly there is absolutely no requirement in the application process for legal assistance.
Right, and I agree with you, and I've stated that publicly on this task force a couple times. Joan, I think these questions are important just to get.
Oh, no, I agree. I was just going to add that I think it's clear to everybody that the federal law states that anybody can complete an application. Where there's the gray area, I believe, is in one of Sarah's slides. It said that there's income and asset requirements, and that gets very complex. There's no mention on there that there's several exemptions. There's several reasons why you might want to seek legal counsel to be able to see if there's ways that you don't necessarily spend down. In fact, I've had clients who've come to me and they're told they do not qualify for services because they're over the income threshold, when in fact there's a way to qualify for services through a pooled trust. And so, what I'm seeing in practice is, people are being told you have to be below this income level or you have to be below this asset level, but they're not being told that there are a lot of different exemptions and there's ways around it. And unfortunately, sometimes it means people are home needing service and not paying for it. They can't afford to pay for it on their own, and they're told they can't get it. So that's where I think there's a big gray area that still needs to be addressed.
Yeah, no, and I hear you on that. And I think I've stated that, and we've talked about this in the first two meetings, there are lots of reasons, very good reasons, why you should consult not just an attorney, but an attorney who specializes, if we can use that word, in elder law in the long-term care Medicaid eligibility determination and process in Connecticut. I'm just trying to get down the foundation of what are the rules. Peter, Matt, would you agree also, though, even though you're not willing to opine on my previous question, and that's perfectly fine, would you agree that a state can't enact any rules or laws that create any sort of impediments or barriers to a person seeking in a third party or independent view in assisting them in the application process?
Well, certainly the state could not enact any provision that would conflict with federal law, which allows a broad assistance in the application process, right?
Okay, thanks so much. And I think I'm going to save some of my questions for attorneys generally, members of the Connecticut Bar, versus attorneys in Connecticut, like some of our speakers that I'm very familiar with. I don't know Attorney Levine personally, but I'm very familiar with her advocacy at the Capitol, as well as Attorney Edward Long. I'm anxious to hear about what relevance the New Jersey attorney has to this process, but I'll hold there for a moment. But just a couple of quick questions to DSS, and that's on the issue of the workforce that's currently assigned to process the applications. And in other words, is there any sense of how many eligibility service workers are currently employed in the system right now?
Yeah, Matt, we can probably provide that information, right? We have folks who are assigned to specific units that work on long-term care, whether it's both applications or processing renewals. Yeah, we can go back and get that information if it would really be useful.
Yeah, and then the second piece, and that you don't need to provide this now either, Peter, and it's the information on the caseloads. In our last meeting, maybe in the previous meeting, we did talk about how there's nearly 1 million people on Connecticut medical or Medicaid assistance in Connecticut, if you include the qualified Medicare beneficiaries that also receive a Medicaid benefit in Connecticut. You know, and some number of years ago, there wasn't even nearly that many people on Medicaid in Connecticut, and the workforce that is assigned to process these applications, I think I would just sort of say that it has not grown commensurately along with the demands on the system. And we have talked in previous meetings about what an outstanding, incredibly job DSS has done in getting what I refer to that tiger back into the cage in terms of processing these applications in a timely fashion within this federal standard of promptness, which hasn't always been the case, and has been, you know, so delayed that it's spurned a legal services lawsuit and had a group of long-term care providers, nursing homes, home care providers, a range of other advocates having, you know, meetings with the commissioner of DSS, and also having quarterly meetings with DSS eligibility regional staff, including representatives from home care and the nursing home industry. But so information on the caseloads and the number of workers assigned, I think that would be good foundational information to have. Anyway, thank you so much for
very quickly to that. I'd love to just quickly respond to that. I think that, Matt, you're oversimplifying it a little bit, right? It's not a direct correlation between the number of caseworkers and the caseload per se. We've instituted a lot of automation into our systems. So, for example, when you talk about 1 million people in the state being on Husky, the vast majority are being determined eligible under the MAGI standards, which we operate in conjunction with our partners over at Access Health. It's a highly automated process, real-time eligibility determinations. Long-term care is substantially longer and slower eligibility evaluation, but it's just not an apples to oranges comparison. So I just want to just note that.
No, thank you, Peter.
Thanks, Peter. There are actually 3 hands all went up at the same time. I'm not sure who was next, but Matthew and Anna both have hands up. Matthew, do you want to?
Anna was first, yeah.
Okay, go ahead, Anna.
Thanks. So I guess, you know, Peter, you had mentioned sort of the automation of the process. When DSS is looking at these applications, is there, for long-term care in particular, is there any kind of advisory aspect within that process, or is it just strict black and white determinations? Or as the applications are being assessed, if at some point somebody says, this could be structured differently, or there's something about this application that appears to maybe not be in the best interest of the applicant, are there any options for the folks reviewing those applications to step back and provide any of that sort of assistance? Or is it just a really clear, like, you filled out the form correctly, we can proceed? Could you just speak a little bit more about that?
Yeah, I mean, I don't think I can necessarily capture every circumstance that may come up, but workers are certainly able to have conversations with the applicants, and they can talk about what they're seeing and what the information that has been provided. As far as providing legal advice, I would certainly not think that they would do that. Again, they're not attorneys, and even we do not encourage our attorneys to provide direct legal advice about how to structure, some sort of particularly, a trust or something like that for a client. That is something that is, depending on how complex a person's finances are, it does raise the question of how they're going to go about qualifying for Medicaid. Keep in mind, of course, Medicaid is intended to be the program of last resort for the people who have the least assets and income in the state. So, if someone has some complex financial situations that they need to figure out how to qualify for Medicaid, that's something that they may have to do. For the most part, though, if you submit your asset and income information, that's what we base our evaluation on. And I just note, we also do check against things like our asset verification system to be able to see and identify, financial institutions' accounts and the like that may not have been disclosed initially. So I'm not sure if I totally answered your question, but I think there's a lot of different circumstances, and workers are certainly, can have a back and forth with a client when they're applying.
Okay, so in those cases, if a worker says, wow, this seems really complicated, I'm not sure that the application has sort of captured all of the all the texture here. What would the worker do? Do you refer to area agencies on aging? Do you refer to attorneys? I mean, are there any referrals outside of DSS for folks? I guess I'm just trying to understand, from the applicant's perspective, what does that look like if it does appear to a DSS worker that they have maybe a more complex financial situation than they would have thought?
I don't know, Sarah, I don't want to put you on the spot, but do you have any thoughts about how, a case might come in and how you might have, having not been having been someone on the front lines processing, though Sarah has been in the past. So just, if she's got any thoughts about how she might, respond to a question about similar to what you just posed, Anna. If you got something, Sarah, feel free. Otherwise,
I can try. So as each case is different, if a worker happens to see something that's very complex and they feel that it's not in the best interest, or they suspect any type of elderly abuse, we do have social workers in the agency, and that's the only internal referral process we have that I know of, and they kind of reach out and have their own process for investigating that. But as far as externally, the eligibility staff, to my knowledge, doesn't have any avenue other than consulting with our legal team at DSS.
Okay, great. Thank you.
Matthew, your hand's still up.
Yeah, I don't know if Peter or Kristen or perhaps Sarah could just give maybe a 25,000 foot level as to some of the training that might go in to a new onboarding of a eligibility services worker in long-term support, prior to engaging in these conversations with clients.
Yeah, I can give it a shot, and Sarah, please feel free to chime in, since I think you've gone through it more easily than I would have. In general, I just wanted to say, DSS staff do go through an extensive training just to become a sort of full-fledged eligibility services worker. Matt had referenced earlier, Connecticut career trainees as an entry point into service with the Department of Social Services. That training generally takes 6 months. We put a lot of time and effort into educating our staff about DSS programs and processes in general. And then there's additional levels of training and experience required to participate in long-term services and supports. I can't remember exactly how long off the top of my head. Sarah, do you remember how long that training is for long-term care?
Yeah, it's about 8 to 9 weeks of LTSS focused. Yeah.
Michael and Jackie both have hands up. I didn't see which one went up first. Jackie?
Jackie.
Okay, thank you. Thank you, Joan. And thank you, Sarah. Your presentation was very helpful. And I'm not sure if Sarah or Peter can address this question, but piggybacking on what Anna was just talking about, is there any consistency in the questions or the review of income and assets between what an applicant might have to apply if, for instance, they had already applied for affordable or subsidized housing, which also requires a review of income and assets, and if that paperwork and documents and review has already been or recently been done, is there any consistency to make it easy on the applicant that they may have already collected those documents and could in fact make the process go a little smoother for them? Do the questions ever align? Is there any crossover between what might be asked for an income and asset review for affordable or subsidized housing, and those questions might be similar, and that might be a way to expedite the process or to help someone who might need an advocate to get through the process?
Well, I'll just note very quickly, right, that DSS doesn't administer the subsidized housing program. So we don't have access to those records. What we would have access to is records that were submitted or documentation that was submitted for any of the programs that DSS administers directly. For example, if they applied for SNAP, we would have access to that information. Almost always for long-term care, we're going to require an additional set of information. We don't have asset tests for a lot of our other programs. So that introduces a host of information that we need to collect specifically to long-term care. So that's one thing. I will say that, I think that at a statewide level, there's a lot of interest in being able to facilitate sharing of more information from the client's perspective, right? If they've submitted something to the state more broadly, that we would then be able to utilize that in sort of making processes better. It's definitely a priority, I know, of the governor and of our commissioner to help facilitate that work. It is ongoing. There's a lot of focus right now on improving sort of the online experience as one of the ways to improve that, as well as doing data sharing and the like between agencies. But specific to seeing other documentations from other places, that's probably a longer, slower process, to be perfectly honest.
Thank you.
Michael and then Marie, and we're at about almost 10:45, so we probably should move on.
Okay, yeah, I just had two questions. First, for our DSS guests, I just wanted to, ask if any of them have any awareness of fraud as related to issues from third parties who charge for Medicaid application services, whether a service provider, whether an attorney, whether it's someone who charges, leading to like denial of services, but those assisters keep the money, and are there any awareness of complaints regarding that?
I'm sorry, could you repeat that question? I didn't catch part of it. I was breaking up a little bit.
Okay, no, certainly. What I'm asking is DSS or any of our DSS guests aware of issues arising from applicants who are complaining to DSS saying, we have paid for assistance for this application, we were denied, and whoever provided us that assistance has kept our money and we are therefore defrauded? Is there any awareness of that?
I'll start off with from the legal side. I haven't seen that come through us. And then Peter, if you're aware of anything, and again, that type of complaint may go to, if there is, to Consumer Protection or the Office of the Attorney General. But I'll say from a DSS internal legal perspective, I haven't seen that in the last couple of years that I've been with the agency.
Okay, thank you. And just as far as, and I could open this up to the whole circle, but I'm just interested about, are there any pro bono services that have been offered by elder bar attorneys towards DSS, or referral lists of attorneys who could work at discounts and also offer multiple language assistance. Is there any awareness of that from anyone, so we can kind of like help bridge these gaps and make sure that folks get their all their needs met? That's a question generally for the floor.
Anybody want to, is that why you have your hand raised, Steve, or did you have another comment? Okay.
Good question.
Okay. I know that as lawyers, we're supposed to do a certain percentage of pro bono. So, but I don't think there's anything that's set by the bar that says, you have to do a certain percentage of pro bono for Medicaid applicants. So I'm not aware, and I do not know. I actually tried to reach out to see if the legal services does Medicaid applications, and I wasn't able to get an answer. But they're available for people who have meet their requirements for below a certain income level. I just don't know if they do the full Medicaid application.
Yeah, thank you for that. And I'm just curious because as we've discussed a couple of times, I believe that there's through the Choices program, I believe that they have at least assistance in Spanish. I'm not aware if there's assistance in other language, but I think it would generally be interesting to understand kind of our capacity as a state, as we have an asset-based approach. Are there folks in the elder bar, for example, who speak kind of unique, discrete languages that might be able to at least raise a hand and say, hey, for folks who need to speak Urdu or Vietnamese, we may be able to assist them. And similarly, DSS saying, hey, we have folks who need that sort of assistance. And I'm just thinking out loud about how we can make these sort of connections so we can, again, have the best information and folks can make their decisions. But I just kind of wanted to make that reflection. If anyone wants to respond, that's fine. Otherwise, we can move on.
I can just very quickly note from the DSS perspective that we do offer interpretation services through the language line service, and that it covers just about every language you can imagine. So we do and have and can support conversations in many languages.
Great. Marie, you had your hand up.
Thank you, Joan.
Yep.
I just wanted to, again, bring us back to the profile of our clients, and especially when we're talking about the way Connecticut has worked so hard to rebalance and provide home care services in the community. When an individual is waiting for Medicaid determination in the community, that's where we see exposure to potential fraud, exploitation, and neglect. The longer that they are out in the community, waiting for that Medicaid application to process. And at the same time, we're touching that client at the most vulnerable point in their life, where cognitive challenges, physical challenges, and when we're looking at Medicaid, in some cases, we're looking at generational poverty that's affecting multiple generations. And when we're looking for family members, I think Peter spoke about the fact that everyone should be able to complete an LTSS application. Unfortunately, the profile of many of our clients is such that they've never made it through high school. They have minimal literacy, and that is a generational situation. So there's no adult child who's going to swoop in and be able to understand that application. Peter, you even mentioned the fact that long-term services and support eligibility workers receive numerous hours of additional training on top of the typical eligibility training. So that's pointing to the fact that it does take expertise to get through that application. And, of no fault of DSS, some of our clients are looking back to Puerto Rico to find a birth certificate or, a marriage that dissolved 40 years ago and trying to come up with that documentation from Alabama or Puerto Rico. It is a complicated, I don't want to lose sight of the fact that the clients that are coming looking for Medicaid help are the most vulnerable in many cases. And if they do have assets left, it's very minimal. And the idea that they would need to use that very limited asset to try and work through their application is a problem, because it might be that roof repair or the furnace that allows them to stay in the house, or seeking help to have someone help put together the application. And although SNAP and Quimby ask a lot of the same information, I can't tell you how many times an older adult has failed to redetermine because they filled out something for SNAP or Quimby and thought that that covered their Medicaid. It is very, very confusing to a layperson, not to those of us who work with it all the time. So I just want to point that out. And Joan, I'm trying to be very cognizant of the relationship between Freud, neglect, and exploitation, and the difficulties within the application. But I think we do have to look back at the profile of the client and really take that into consideration. Thank you.
Thanks, Marie. I agree. And that's one of the things that we were talking about earlier, Michael and I, with the checklist, because there are certainly people who could benefit from some application service assistance through Agency on Aging and really help them through that process. But we want to make sure that the people who they don't necessarily just spend down to the limits that are listed in black and white, because they may not have to do that. There may be a disabled child at home who then would have no money left, or there might be a spouse at home. So those are the areas where I find that we really need to educate people more about it, because seemingly very simple factual circumstances for them, like they're married or they own a home, might not seem like it's a complex situation, but it does make it more complex because there are so many laws and exemptions related to that. So that's where I think a potential checklist or disclosure could help. So it's 11 or 10:51 now. I know Jerry said that he pushed his meeting to 11:30, so he's got a little bit of extra time, but I think at this point, I'd like to move on to him, so we have an adequate amount of time. And just for Matt, you had mentioned asking what led us to invite Jerry. It's really to see what other states are doing, because as part of our resources list, we do have the list of the various states that have been working on this issue. So we thought it would be helpful to hear what they're doing in New Jersey and what he, in his opinion, is working and what's not working. So we can kind of pull from other areas.
No, thank you so much, Joan. And just briefly, in referencing back to last meeting in the agenda, when the agenda was published, I was not aware that one of the attorneys that was presenting at our last meeting had pending litigation against the company, the Medicaid Application Assistance Company that I had been requested to invite to the meeting. And I just thought that to begin with, if it's not unfriendly, I hope it isn't, that Attorney Rothkopf will provide any disclosures that he thinks might be beneficial to the benefit for the members of the task force, even before he begins to speak. You know well that I have disclosed my relationship to a Medicaid Application Assistance Company previously, and I thought that might be proper to begin with. Thank you.
Well, I think based on my meeting with Michael yesterday, we've agreed that we're not going to be talking about ongoing litigation. So I don't know how much you want him to talk about that. But he was going to be talking about what he's seen in New Jersey and what New Jersey has been doing. So.
All right. Thank you for your consideration, Joan.
Jerry, the floor is yours.
Well, thank you. And thank you to the committee. My name is Gerald Rothkopf. I'm managing attorney at Rothkopf Law Group, an elder care law firm, both based in South Jersey and southeastern Pennsylvania. So our practice is limited to the great Commonwealth of Pennsylvania and the wonderful state of New Jersey. And thank you. Just from my perspective, we in Jersey tend to be a little cynical. So let me just say that it's great that It's a multidisciplinary group, and we don't see that in Jersey. So I commend you, from DHS to state representatives, to elder law attorneys, to the nursing home and long-term care industry representative, Mr. Barrett. I commend you to getting together in Jersey to get all those folks in a Zoom room, let alone an actual room. You'll need a papal decree for that to happen. So I commend you for that, number one. And thank you for your time today. And Mr. Barrett, I'll be happy to give you full disclosure. No problem. Yes, I'm aware of the lawsuit. I'm not going to discuss it. One of my clients is a class representative of that lawsuit. So, okay, that's my disclosure, but I'm not talking about that lawsuit. And that's how I know Attorney Tedesco as a result of that. But I am not counsel to the lawsuit and will not be talking about any aspect of that lawsuit. So what I was asked to do is give a little historical perspective, and then what has Jersey done to address it. And because what you're dealing with, and I'm specifically related the issue of Medicaid advisors as a whole cottage industry I'm talking about. So what you're dealing with over the last few years in Connecticut has emanated from New Jersey. And I want to put some historical context on that, if I may, so you'll understand what has been going on for the past 15 years in New Jersey. And I want to be clear, I think the issue of UPL, unauthorized practice of law, is a red herring. Senior fraud, financial abuse against seniors is not about unauthorized practice of law. It does not matter whether you're an attorney, a DHS worker, or an unlicensed Medicaid advisor. Fraud is fraud. It's simply black and white. It doesn't matter who's committing it. If you are an attorney that has an interest in a nursing home, and you also are a partner in a law firm, and you're not disclosing that, and you then purposely don't advise the client of the inherent conflict of interest, that's improper as well. It doesn't make a difference what your license is. Financial abuse of seniors is financial abuse of seniors. So I don't think this should be analyzed in the context of an unauthorized practice of law. We as attorneys, that's what we're trained to do. But I listened to the video testimony. I watched it on YouTube yesterday. So I don't want to rehash those issues, the testimony or those issues. But to argue purely a UPL, in my mind, is an exercise in futility for a variety of reasons. Number one, Mr. Werner, you addressed this. You have antitrust issues at work. You also have the issue of the First Amendment. You cannot control free speech here. There are GCMs, geriatric care coordinators, violating UPL statutes in the state of Connecticut. Okay, I'll limit it to New Jersey, but I'm sure it's happening in Connecticut. There are financial advisors who are advising people to purchase annuities who are committing UPL violations. But if you're going to go down that road, you'll be playing whack-a-mole for the rest of your life. It's not going to be a successful endeavor. But what I want you to concentrate on is the issue of financial abuse and undisclosed relationships among the long-term care industry. That's what needs to be addressed. And when we analyze the issues, and I'm not here to deal with issues of hyperbole, but we cannot analyze issues in a purely legal context. Is a UPL violation, is a not UPL violation? So why do these companies exist? And Mr. Barrett, I agree with your line of, the relevancy with your line of testimony earlier, in the sense that these companies exist because they filled a need. That's why these companies exist. And really, in New Jersey, these companies, this cottage industry started out 15 years ago. So whatever started out in New Jersey went through the Lincoln Tunnel, the Holland Tunnel, up the Merrick Parkway, and it landed in your lap. And so why do these companies exist? These companies exist because they fulfilled a need of the nursing home industry. And understand, these companies, their food source is the nursing home industry. And these companies cannot operate without the complicit consent of nursing home owners and operators in New Jersey, Connecticut, and beyond. And I want to be clear on that. And so what happened was that some of the largest Medicaid advisors, specifically in New Jersey, already represented nursing homes. So I don't want to rehash the issues. You know the companies I'm talking about. So they represented the nursing home industry. They did 15 plus years ago. They did back office billing for that. So what happened was that the nursing home started coming to them and they said, well, we're not getting paid. We have this Deficit Reduction Act that took effect in 2006. And now, the penalty period does not commence until until the penalty period expires. So we're not getting paid. We're stuck with the bill. And on top of that, they were complaining about elder law attorneys hiding money from the nursing home owners and operators due to legal means. So nursing home industry wanted to start controlling the process of the filing of the application for Medicaid. So these companies who already represented the nursing home, already had the full census of the nursing homes, they started their separate cottage industry. And then there's different different companies have spun off as a result of that. And understand, these companies do have a role to play. It's just not the lane they think they're in at the moment is the right role for them. And so what have we done in New Jersey to try to counteract that with, I would argue, limited degrees of success? The first thing is that we met with myself and several others of the Jersey Bar. I'm the former chair of the State Bar Elder Law Association, the former president of New Jersey NALA. So in my role, we met with the representatives from the Consumer Affairs Department of the New Jersey Attorney General's office. The most we were able to get is a consumer alert. Good luck with that. That was about in 2017. We also, during the time I was chair of the State Bar in 2016, we asked the New Jersey State Supreme Court for an advisory opinion as to the lane in which these Medicaid advisors can practice. And we based our request on what the state of Florida did a few years earlier. And we received an excellent decision that says the Medicaid advisors, this is from the New Jersey State Supreme Court, they're limited to getting the necessary 5 years worth of financial documentation together and submitting the application. That's it. Nothing, no spend down, regardless of what is public information. Just because it's public information, then you have to take that public information and apply it to your specific client. That's still a practice of law. So that is what happened. So what was the result? The result was these companies simply changed their business practice. It was a bad result, is the answer. Because let me back up. Because this has, the decision has no teeth. There's no enforcement powers by the state. Supreme Court has no enforcement power. So you literally have to take that UPL opinion from the New Jersey State Supreme Court in 2016. You have to walk. I live in the township of Cherry. I'm sitting in the township of Cherry Hill. I live and work here. I literally have to take that opinion, walk it over to my township police department and file a private criminal complaint. That's how you would argue the UPL issues at the moment. So obviously that's not successful. So what some of the companies have done in New Jersey, at least, is they basically teamed up with an attorney, a law firm. And now, after that opinion came out, when the companies hire, when the consumer hires the Medicaid advising company, they automatically get an attorney at the same time. And guess what? The Medicaid advising company is giving the consumer who they sign up 2 documents, 2 fee agreements. 1, the Medicaid advising company agreement. 2, the law firm fee agreement simultaneously. So that was the result of this advisory opinion. Not very helpful, in other words, at least to the consumer. So the bottom line is that I commend you for forming this committee because we haven't had very much success in Jersey doing what we've done to date. And I want to be clear about these companies. They cannot operate without with the complicit consent of the nursing home industry. And on top of that, because that's their food source. And on top of that, they know going in, I have clients who come to me with $200,000 in assets, say I hired a Medicaid advising company. What could the company possibly do to advise them to spend down $200K? But they accept their money, $6,000, $8,000, $10,000 in upfront flat fees. And when they know going in, they themselves legally cannot assist that client, but they gladly take their money anyway. And probably 50% of the time, do you know what happens to that individual who paid $6,000 to $10,000 during the course of a $200,000 spend down for a single individual? Yes, they're dead. Guess what? That $6,000 to $10,000 fee, no refund. That is going on in Connecticut, and that continues to go on in New Jersey. So even though the individual died, because the fee agreement says, because it's not our fault that we didn't file an application for Medicaid to its conclusion, because you're dead, it's not our fault you died, no refund. And that goes on constantly. So what can be done? I refer you to testimony of Attorney Tedesco, but I think that will have limited benefit because of the nature of you're dealing with a very emotional client. In many cases, you're not dealing with the client themselves because they may be incapacitated. So you're dealing with a legal representative. And it's at a very emotional time, the nursing home placement, and giving them additional disclosures, I think will only go so far, but I certainly would recommend to address any potential conflicts of interest. But I also think I would look at this, and again, I don't mean to engage in hyperbole, but this is Jersey talking. I would look at this as how you would analyze organized crime. And I don't mean to say that lightly. Because you have layers of corporate shell games going on. And this needs to be addressed in different agencies. I believe the nursing home industry has a role to play. I believe the Attorney General has a role to play. I believe DHS has a role to play. And I believe private practicing attorneys have a role to play to address these issues. And once again, it's the financial abuse of seniors and the lack of disclosures and the lack of information that's being provided due to inherent conflict of interest that's occurring. So I thank you for your time. I'll be happy to address any questions. And I'm sorry I may have taken a little more time than expected.
Thank you. I have a question about the original solution that you mentioned that New Jersey came up with, the consumer alert. What did that entail? I know you said there was really no teeth to it to enforce it, but what was the consumer alert?
Consumer alert was simply put on the age, I've circulated among my attorneys and even to nursing homes. It simply said that, this is to advise you that you have a right to use your own attorney, that, third-party unlicensed Medicaid advisors may not have proper knowledge, and may not be working in your best interest. That's basically what the alert said.
And who was obligated to circulate it, or was there
No
any
one was
obligation?
obligated.
So it was put forth,
It was-
something written up, anybody could share with anybody, but nobody was obligated to share.
There was no obligation to include nursing homes, for example, to include that alert in their admission packet, for example.
Do you think it would have been more helpful if it was an obligation?
I think it would have been helpful, but it would have been page 92 of a 101 page nursing home admission packet, if you understand what I'm saying.
Yeah. All right, muted myself. Does anybody else have any questions?
Oh, it looks like Michelle has her hand up.
Go ahead, Michelle.
Thanks, Joan. I just wanted to follow up to what you were asking. I'm just curious if it's as simple as is there anything on the application that notifies any individual of this law or anyone who assists in the process?
Was that a question for myself?
I'm sorry. Do you know if on the New Jersey long-term care application, if there is notification of this, if it makes people aware that
I'm sorry. On the application, no, you mean of the alert that exists, the consumer alert?
Well, there's the alert, but also I'm just curious if, is it DSS or DHS in New Jersey who puts out the application for long-term care? When someone's applying, are they notified at all that there is this law, or individuals should be aware that they, what they can and can't do in assisting in an application process?
No, there's no formal, it's not a law. Of course you have UPL, but beyond that, and understand, like, it's federal law. A non-attorney can assist an individual in the application process, including a fair hearing. We all know that. I think, I think that's law, and no argument there. But no, there's no disclosures in the application process, right? No requirements that, you have a right to choose your own counsel or legal representative.
Thank you.
And may I add, I listened to the testimony yesterday, and I just wanted to see what some Medicaid advising companies were up to in Connecticut, which I personally don't have knowledge of. So, Mr. Barrett, I went on I know you're executive director of the Connecticut Healthcare Association. I may have misstated the actual legal name of the association. And I know you had an event recently, I think a dinner event. I'm sure it was a nice event. And I think it was a few weeks ago, but I just wanted to see who the sponsors were. And one of the sponsors was a Medicaid advising company. And I just want to mention, where is their allegiance? And for example, this company, this is in your sponsor book. So I pulled this up on your website. And it says results as clear as black and white. And I'm not going to mention the company name, but it says this company, their tagline was solving the Medicaid challenge for hundreds of facilities. Be next to see success. Well, don't you think if they're getting $6,000 to $10,000 from the individual, that it should say solving the Medicaid challenge for hundreds of consumers? And I'll just leave it at that.
Matthew and Michael both have your hands up, I think. To go first.
Does Matt Barrett, do you want to respond to that?
No, thank you, Michael.
Okay, very good. I'm going to let Matthew ask his question before I ask mine.
Sure. So thank you very much, Attorney Rothkopf, for being with us today. So my question is, in looking at the New Jersey opinion concerning the unlicensed practice of law with these Medicaid advisors or application assisters in New Jersey. The court opined that those groups can provide information on insurance programs, coverage options, help complete the application or renewal, help with the gathering and providing of required documentation, assist in counting income and assets, submit the application to the agency, and assist with communications between the agency and the individual. And then the final clarifying sentence is that, but the advisor may not provide legal advice on strategies to become eligible for Medicaid benefits, including advice on spending down resources, tax implications, guardianships, sale or transfer of assets, creation of trusts or service contracts, and the like. And you had mentioned that after this opinion came down that the planning services changed their business practices. I was just curious how, just if you could clarify a little bit as to how the business practices changed after this opinion, and it just in particular in what ways that you felt that those changes, just from implication, as a way to get around this distinction between assisting and then crossing over into the practice of law.
Okay, you were almost correct with what I stated. I did not state it was any particular company, but you inferred correctly. So what happened was that the opinion, as you correctly stated, said, basically anything other than gathering the financial documentation together and filing the application is the practice of law. So soon after the opinion came out, I started seeing documentation from clients coming to me, in some cases after they hired the Medicaid advising company. And this law firm was there in the packet of information they provided to me at the initial consultation. What is this? So then I soon began to realize that at the time, in order to get around the practice of law issue, at the time that the consumer was engaged, the Medicaid advising company, they were given two fee agreements. One was the Medicaid advising fee agreement. The second was the attorney fee agreement. And the attorney fee agreement said, for $350, you're going to get an initial analysis of any legal issues that need to be addressed. And the law firm was not present when the client was signed up as a client. And the Medicaid advising company collected the fee on behalf of the law firm. I'm going to leave the ethical issues of the law firm out of this for today. And that is what was their business plan changed. So they can silo saying, well, we're not practicing law. But the question is, who is the quarterback here? I'll leave that as an open question. So that's how they changed their business practice. And then the law firm, then after they analyzed, they said, oh, well, you're going to need an annuity. You're going to need a care contract. You're going to need an irrevocable trust. It's going to be another $8,000 on top of what the fee was they paid the Medicaid advising company. So that's why I was referring to earlier. So these companies know at the outset that they alone cannot assist the client in isolation. So that I would argue that contract with between the consumer and the unlicensed Medicaid advising company is 100% illusory in nature, because they know when they accept the money, they alone cannot complete the job.
So, and I'm sorry, Michael, just one quick follow-up there. Isn't then the real issue, because it seems to me that what you're saying is the attorney, I mean, I think, isn't there a real issue with the ethical issue with whomever that designated attorney might be? Because it seems to be that you're implying that in New Jersey, that these designated attorneys are truly working not in the best interest of who is now their client, but of the the nursing home or that corporate entity. And so maybe, at least from my mind, is it not so much with the a planning agency as opposed to here's a referral, now you're signed up because you've cut 2 checks, and now isn't it really on whomever that firm or counsel is who is not representing the best interest of their client, but rather a third party who's interested in what's best for them?
Well, that's the whole Medicaid advising shell game there. I mean, but ultimately, they're both to blame. I agree with you, Matthew. Yeah, the attorney has some serious issues going on. There's no doubt in my mind. But so does the Medicaid advising company. Because where did they? Well, I mean, we can go on and on this, but you know, again, they admitted in essence that they alone cannot do the job. So that's the issue from the Medicaid advice company, as well as the inherent conflict of interest. I mean, I've gotten calls. I'll give you an example, and I know I apologize for the time. I'll stop if you tell me to move on. I'll certainly end my speaking. But what I will say is that for example, I've gotten calls from clients who've engaged our services, who their loved ones in a nursing home, and the law firm service I'm talking about, and they say, I got a call from this senior something company, and they wanted to know if I needed assistance with my mom's Medicaid application. So I called, and I know exactly what they were referring to. So I call the executive director of the nursing home, who I'm friends with, the administrator of the nursing home, who I know on a first name basis. And I say, Becky, what's going on here? I think I know what's going on. Just back me up on this. Is this company, is this the parent company? Do they do billing for you? Yeah, why? I got my answer.
I think to me too, just to touch on Matthew's comment that the whole referral for $350 is like a bait and switch. If you've already signed a contract for $6,000 or $8,000 for somebody to help you with the Medicaid application, and then you have to pay $350 for a consult, and then that law firm then comes forward and says, oh, by the way, now you need legal help and it's going to be another $8,000, and you're not entitled to a refund from that original contract, you're kind of stuck. That's what I see as the issue there. I want Michael to be able to speak. His hand has been up, and then we really need to probably move on because we have 2 more speakers.
Yes, thank you, Joan, and thank you, Jerry, for speaking with us. I appreciate what you've been saying today. And 2 quick questions. A few moments ago, you talked about fee agreements and maybe clauses for refunds in case of death. I think that's actually sounds pretty good. Is that something New Jersey does? Is that something we should do here?
Was that a question for specifically related to? Are there any
you were discussing about when a client dies in the process, right? And can there be a refund? So I'm just simply asking for vendor fee agreements for those who charge for services. Do they have required clauses for refunds in case of death in New Jersey? Is that something that we should do here?
No, there's no required clauses for a refund. What I was referring to specifically, Michael, was specific situations where a company accepts money at the outset when they know for a year or 2 the individual cannot possibly qualify for Medicaid because they're over-resourced. And during that time frame when they're spending down, when the company's really doing nothing, the individual dies because that's because they're chronically ill in a nursing home, and there are no refunds because the fee agreement specifically states that unless the failure to qualify for Medicaid was our own doing, no refund shall be received. And so that's what I was specifically referring to. Now, in all cases, now, in an attorney's case, you may do all of the work, you may do the trust, you may do everything, and the client dies. There may be a partial refund due because it depends on what work is performed. That's the issue. What's the value received prior to death? Not a blanket statement that it all should be refunded or not refunded. What was the value? And is the issue, is what I was getting at. And in this case, and so what happens, so if the no refunds, if an attorney or sometimes get involved, they'll say, okay, the fee agreement says no refund. We're nice people. We'll give you 50%. We'll give you 4,000 back. Oh, by the way, in order to get that 4,000, what do you need to do? You need to sign a non-disclosure agreement. That's the only way you're going to get money back, if you understand what I'm saying.
Okay, that's an interesting area of opportunity that you highlighted. I appreciate it. And lastly, I was just interested, if we're going to compare kind of apples to apples for those of us here in the circle, whoever may be watching, we've heard a couple times now how some of these planning services companies can charge $6,000, $8,000, $12,000. Can you give us a general idea what are the fees for elder bar attorneys in Connecticut or New Jersey for their services?
I'll let the Connecticut attorneys speak for themselves because I don't practice there. And it's really difficult. Well, let me just preface this by saying, and I know this was touched upon by Joan, as to what attorneys do. I can't tell you what other people charge, but it's what the value is. We analyze, we're attorneys, and we analyze the case. We advocate for the client. We have insurance. We have a license. We have the certain training. We have certain license. Some of us are certified elder law attorneys, CELAs, which specific which is specific training and exam and recognized by state bar associations. So it's very difficult. We're not comparing apples to apples here. So do elder law attorneys charge more? I would say they do. Yes, and they should, because you're rendering a significantly higher level of service. You're providing advocacy. You're providing advocacy for the individual as to, well, what happens if they want to come home? Well, what services are going to be in place at home? You're analyzing the nursing home contract upon admission. You're analyzing their Medicare coverage and assisting in Medicare appeals. You're analyzing the spousal allowances. Are there any exemptions that apply? Is there a caregiver child for a transfer of real estate? Do we have a child with special need? Does a special needs trust need to be established? We're analyzing gifts done 4.5 years ago within the 5-year look back. Is it a gift? Is it not a gift? Can we do a loan? Are annuities appropriate? We have to deal with the state recovery. We have to deal with the sale of the real estate. I can go on and on, but I think you understand where I'm coming from. It's not a fair comparison.
Okay, and thank you, and sorry. And with just one last question, just touching on an earlier point, I'm just curious, does the Elder Bar in New Jersey, do they have any kind of dedicated pro bono services or discounted services that they may offer to folks who may have lower incomes but still have the needs or diverse language services or anything like that?
Not related to the filing of an application for Medicaid, not that I am aware of. We required, I'm sure Connecticut is, by the state bar to maintain our legal license, to engage in a certain amount of hours of pro bono work, but not specifically related to the filing of an application for Medicaid. So I am not aware of any state regulation that there are any specific programs for pro bono work related to the Medicaid application process itself.
Thank you. Joan?
Thank you. Thank you, Jerry. We appreciate you coming. It's 11:28 now. I know you said you bumped your meeting to 11:30, so I appreciate all your information. I think that was helpful for us. And if you have to pop off, we'll understand. But I do want to move on to Ed Lang and Linnea Levine. I'm not sure which one of you wants to go first. If you have a choice, it's up to you. Ed, do you want to start? You're muted.
Okay, I've unmuted myself. Apologize to Linnea for getting in her way. But this has been very interesting, and I think it's really, really useful that you started off today with the presentation from Sarah, because that presentation showed what happens as you go through the application for Medicaid benefits. But it totally ignores, and I shouldn't say ignores, it doesn't discuss all of the work that goes into planning for a Medicaid application. I think just knowing who's on this Zoom meeting, all of you know that federal law and the Connecticut Uniform Policy Manual provide specific methods, legal methods, that people can use to transfer assets, to protect assets between spouses, for disabled children, for caregiver children. There are just a number of things that people can do before they submit a Medicaid application, legally, ethically, morally, to protect their rights as specified in the federal and state law. Give you a simple example. I had an individual who was a caregiver for his father. His father was elderly, blind, and suffering from severe progressive dementia. The father had a medical emergency and wound up being in a long-term care facility. As the father's funds were being spent down, the business office at the facility contacted the son and referred him to a private firm to prepare a Medicaid application. They did not provide the son with any type of legal advice at the facility or from the firm that was preparing the application. The son contacted me because he was interested in knowing whether he really had to sell the father's home after the application was granted, or was there a method that he could use to possibly take out a reverse mortgage for the father so that they didn't have to use up all of their funds, or that he wasn't going to wind up being impoverished. He had quit his job to stay home and care for his father. I was able to advise the son that he could apply for a conservatorship, which he did. We asked the probate court for permission to turn the property over to the son as the caregiving child. And then the son went back and worked with the private agency, and they prepared a Medicaid application. And ultimately, the father was granted the Medicaid benefits, but the son was able to keep the home. And what I see, and I think what Jerry alluded to, and what some others have mentioned, is that there are a number of legal planning opportunities that are totally missed when a long-term care facility simply refers a resident or a resident's family to a private firm that prepares an application. And I think, as Attorney Tedisco mentioned in your last hearing, as Jerry mentioned today, if we can do something to require that if a facility is going to refer the resident or the resident's family at this very difficult, very emotional, very overwhelming time, if we can require the facility to notify the applicant or the resident that they have certain legal rights, and that before they submit a Medicaid application, they may want to explore what opportunities exist. So we're not saying don't make a referral to an agency that does an application, but disclose at the time that you make the referral, not buried in the 45-page Medicaid, admissions process. But if a facility is going to make a referral, at that time, make a disclosure to the family or to whomever they are making a referral. And I suggest, and I'm looking down because I wrote it out, that referral or the warning at that point should state that federal and Connecticut law provide that an individual will not be penalized for transfers under certain circumstances, and that legal opportunities exist to protect some of your assets. I think the family should be told that the family should know their rights before they commence the Medicaid application process, and that the company to whom they are being referred does not provide any legal services or advice, and that the family may not rely on the company to furnish any legal services. And again, without being specific, I have looked at some of the agreements with the private firms who prepare Medicaid applications. And in their contract, it specifically says, we do not provide any legal services or advice, and you may not rely on us for any legal services. So if we require that that be stated in the referral from the facility to the residents, I think we've taken a big step to making people aware that they have opportunities, that they don't have to impoverish their disabled child, that they can protect a house for a caregiver child, and many, many other opportunities. I'd be happy to answer any questions, but I think we do have an opportunity with this group to take a significant step to protect people and make them aware of what they can do instead of having to spend down all of their resources. Thank you.
Thank you, Ed. Matt has his hand up.
Thank you, Joan. And thank you very much, Attorney Lang. And your remarks really reflect the sort of keen mind, intelligence, and experience that can benefit so many people in this complicated Medicaid long-term care eligibility process, and serve to remind us that there are many, many reasons why applicants should consult an elder law attorney right up front. And we have discussed them in the beginning of the meeting, beginning of this task force. But your remarks really just stand to me as an example of why that is the case. And since I'm familiar with Attorney Levine's presentations at the Capitol, I think she's going to do the same thing, and that her intimate knowledge of the complicated rules. But this really, begins at law school, doesn't it? And I'm a member of the Connecticut Bar. We learn to evaluate issues and spot issues based on the facts that are presented to us right from the very beginning, right? And that's kind of, at such an advanced level, what has been, I think, the mission of your service and your practice, Attorney Lang. And again, you just gave a great example of it. I had a question for you about who is the, this whole notion, and I really reject the language of the bait and switch. Just for a moment, but I think we'll probably talk about that as the committee deliberates or the task force deliberates its recommendations going forward. But since this isn't a question, because I'm absolutely aware that skilled nursing facilities over the years, maybe more so in the past, have referred complicated eligibility determinant applications, families, and those acting on their behalf to elder law attorneys. And that, so the referrals, we have discussed that the referrals certainly are coming or going in the direction of some of the Medicaid application assistance. We still know that referrals are still going to elder law attorneys, and they have been for many, many years. And when an elder law attorney does a good job, the kind of work that you are well known for, and we have a sort of a streamlined and expedited application process within the rules, within the permitted rules that allow the protection of assets, then certainly there are many beneficiaries downstream to that excellent work. And the first one begins with the consumer and their families, correct? But the state of Connecticut is also a beneficiary of that good work. When the application is done well, when it is packaged up, when the issues are evaluated and it's presented to the DSS workers, some of them on this call, then the process goes so much more smoothly. And we have an expedited process for eligibility determination rather than a elongated one. And I guess I would not be apologetic to also concede that the consumer is a beneficiary, the state of Connecticut's a beneficiary, but the long-term care facility who is in reliance of Medicaid payment for these services is also the beneficiary. But I just want to state for the record and ask your opinion about, I completely reject that means they are the de facto client and that there's something untoward or improper about that just because they also are the beneficiaries of the service. And so I liken it very much to your good work and what you accomplish, and there are many beneficiaries downstream from that. And I'd ask you to comment about that if you wouldn't mind.
The frustration that I encounter is one where many of the facilities, and some are much more relaxed, some are much more aggressive, but I find that some of the facilities are being very aggressive about reaching out to families and referring them to private firms to prepare applications and discouraging people from working with attorneys. And that is, I think, is a very big problem. And I think we're seeing people who then are being put in a position to spend down resources or not avail themselves of other opportunities. I don't think it's fair to pick on a nursing home that does this, but we also see people who might be able to return home, who might be eligible for the home care program for the elderly, but because they are in the facility and they're being referred to an agency, I keep calling them an agency, a company to prepare an application, they're spending down their resources and not having the ability to pay for the care at home and pay for getting the advice and the guidance to set themselves up at home. And we're seeing people who are now long-term residents who may have otherwise been able to be at home. And I think Attorney Levine can comment on that even further.
Thanks. Thank you so much, Attorney Lang.
Thank you.
Thank you, Ed. If there are no other questions, I'm going to ask Linnea to speak. We have about 20 minutes left in our scheduled meeting. You're also muted, Linnea.
All right. Can you hear me?
Yes, we can hear you.
Okay. All right. I'm sorry. Okay. I'm going to try and condense this, but I've been practicing elder law for 30 years. I passed the certification test to be an elder law attorney. I'm past president of Connecticut NALA, and I have done a lot of Medicaid applications, a few fair hearings, and 2 Superior Court appeals, which I won both of them. But the thing is that my passion has been my clients, and it really offends me when I hear people say that the attorneys just want to make money, we charge a lot, and all these other things, where I started as a tax attorney for Coopers and Lybrand, and if that was really where my heart was, I would be much, much richer, and but my life wouldn't have been as interesting. So I want to talk about a case that I had that really bothered me, because one of the other things that I hear in the midst, from people is that Medicaid should only be for the poor, right? So I think if anyone has done any bankruptcy work, you should be aware that half of all bankruptcies are caused by paying for necessary medical care. Okay, you know how expensive medical care is, particularly nursing home care. So a lot of our clients end up being, middle class or lower middle class. and they do have assets, and they do have rights. And that's the other thing that I hear myths about. These are not loopholes. These are statutory, federal and state statutory rights. Now, DSS, when they put out all their stuff, and they do a great job, I've worked with them for 30 years. I'm not here to complain about them, but they put down all of the obligations the applicant has to the government. Okay, the nursing home with their 100 pages puts down all the obligations the resident has to the nursing home. Nowhere is there any place a patient's bill of rights for Medicaid applicants, but there is a patient bill of rights for nursing homes. And there was, when I practiced in New York, a client bill of rights for attorney-clients relationships. There needs to be something in writing that everyone has to give out that protects clients who are impoverishing themselves because they are paying for necessary medical care. Now, I want to talk about this one case that I had that really busts a lot of these myths. There was this man, he was in finance with a company in Asia. He was doing very, very well. He had all these corporate benefits. He had his 401k, he had all of this stuff. And he was in Asia, he was crossing the street, and he was run down by a speeding truck. And that speeding truck left this man with a mind inside a body, unable to talk, unable to move. He blinks his eyes. He was medevac back to the States, and he's in a nursing home in Stanford. I did not get this case until, I guess, in 2017. The conservator started the application or the spend down for Medicaid. I asked the conservator, why didn't you go to a lawyer? I didn't know lawyers did that. I was told he had to spend down his assets and his income, so he did. So he spent down all of his assets, spent down his income. Eventually he was on Medicaid. And he was under age 65. He'll be 65 next year. So around 2018, he qualified for Medicaid. And he was on it. There's no need for me. The damage was done. All of a sudden, but he could have put his assets in a payback special needs trust because he was under age 65. He could have put that money in there and he could have had real quality care supplementing the Medicaid care, which this man deserves because he is in a terrible situation. His daughters were paying for companions to go sit with him because they did not live in Stanford, to talk to him, to kind of keep his brain going, to keep him from wanting to die. Fast forward, the conservator completed the Social Security disability application, which was essential because his income was significant long-term disability benefits from Cigna Insurance, okay? That were well above the Medicaid rate for the nursing home, which at that time was maybe $8,000. And his total income, when you added the Social Security and the disability, was $9,350 a month. But then also Cigna over withheld his disability benefits. They over adjusted. And now I got called in because there was a check coming in past income for $50,000. And I was really, really upset. This man, all hell was gonna break loose if I couldn't save this $50,000. So I went to probate court in Stanford. I did a first party payback trust, served it on Medicaid counsel and all of this. And trust was approved like that. But I was informed that, and I didn't know this because I always do it right the first time, right? So there's no such thing as a Medicaid expert, even though I've done this for 30 years. You have to apply for this trust during eligibility, not after you're on Medicaid. Okay. So I went back and I said, well, we could kind of play dirty and we could just go back and we could get them off Medicaid for a month or two and then go back and be eligible, and I could do that. But I said, you never know if you're going to get everything done right and how much of time it's going to take and what we're going to lose in this $50,000. And I really felt this $50,000 key for him to get the extra rehab this man needs and companionship this man needs to keep him from being suicidal. So I worked it out with Medicaid legal. I came back and I said, you know what? The conservator will pay all of the Medicaid, oh, help me. This is a senior moment. The applied income, right? But you can only get the applied income up to the Medicaid rate, which is $8,000 a month at the time. And I feel this extra money. So once you get that, the DSS isn't paying anything. So that's good for DSS, right? He's on Medicaid, but this extra money plus his 50 should go into the special needs trust. And that's what we worked out. And it wasn't a land, but the man was in his 60s. He's going to be 65 in September of 2022, and he won't be able to put any more money in. And kudos to the nursing home, because now the nursing home rates have been raised. So now there's just a couple of $100 a month that's going into the special needs trust. But he has his core $50,000 to pay for him. And I don't know if this is fraud. I don't know the woman that did this, if she knew about this payback trust, but it definitely violated the inherent rights of my client to have a first party special needs trust and put all of his 401k and assets into it in the beginning. So I really, really feel that there has to be a Bill of Rights for Medicaid applicants that DSS has to put out, that nursing homes have to put out, not in page 102. It has to be the first thing they see with the nursing home. They have to get the nursing home Bill of Rights should be on the top, and the Medicaid applicant Bill of Rights. And I feel that's imperative. And I really take issue that the lawyers are out this to make money. I'll make a third of the money I was making at Coopers and White Ranch. So, okay. So I just want to, that's all I have to really say, and I'm open to questions.
Thank you, Lynette. Matt, you have your hand up.
Yeah, thank you so much, Joan, and thank you, Attorney Levine. And as far as I'm concerned, another really fine example of why it can be so important to consult with an elder law attorney, not just in the Medicaid eligibility determination process, but in terms of advanced planning for the future. And since I know of your work from a distance, we probably owe you a debt of gratitude for all the people that you have helped over the years. I just had some questions about an area that you touched on that I think is really important. And I'm aware that you're not as much expertise as you have and all of your experiences. You have probably seen everything, but under the Connecticut rules of professional conduct, you are not allowed to refer yourself as a Medicaid specialist or specializing in Medicaid, even though common sense would say you're a specialist.
Well, I tried to be a specialist.
But you're not allowed.
I call myself a Medicaid maven.
Right. And even though I think some of the firms I'm aware, they hire staff that I think they may be allowed to refer to some of their staff that are sort of packaging up the material, providing quote application assistance under your supervision as Medicaid specialist, but you're not allowed to do that. So consumers get to learn about you probably by word of mouth or by whatever credentials you have. And so I'm aware that there is a credentialing process under the National Elder Law Foundation. Is that it?
Right.
And I assume that you're a CELA accredited.
Well, I was for all these years until 2018 when I had non-Hodgkin's lymphoma. And I'm about to retire at the end of this year. Okay, so I just stopped. I just sort of didn't recertify because I knew I was going to retire. But yes, for like 26 7 years, I have been a certified
Right.
elder law.
So it teaches consumers that this is a person that is devoted really almost solely to this, and does the additional advanced and ongoing learning and education to keep
Right.
these accreditations. And I also think we learned something from your associations, from the National Academy of Elder Law Attorneys, and I just assume that you're a member of the Elder Law section
yes,
of the Connecticut Bar,
Yes,
and so on. But the issue, and we've been discussing this on and off in the task force, the sort of level of expertise that you bring to this work, and Attorney Lang brings to this work, and so many others. But that is not the sort of level of expertise that the Connecticut, to be a member of the Connecticut Bar necessarily denotes. And so yet, there have been complaints over the years, and there will be complaints in the future that attorneys will take on this Medicaid eligibility determination process who are real estate attorneys or just don't have that kind of, and so the kind of concerns that you have been expressed about application assistance companies or firms. Would you also have those concerns about attorneys? And I would want to note though that, and I'm totally aware that there is, if you you violate the rules of professional conduct if you don't disclose conflicts of interest. And there's a complaint process for lawyers who engage themselves in malpractice, fraud, misrepresentation. I'm aware of that, but there is a distinction between your level of expertise and the legal profession generally in Connecticut.
So I think that there's ways that you can figure out who's good. Okay, you can see, like, I'm a past president, and I was on the board of Connecticut NALA. I've taught CLE on Medicaid recovery, eligibility, spousal rights for MBI. And so I've written all, I know the law deep down. And the other thing, whenever I refer people, usually it's to another state, like I'll refer them to somebody, I'll say, look, you don't go to a lawyer to do Medicaid planning if they don't have a history of successfully doing Medicaid applications, because that's how you learn. Unfortunately, my mother's application was the first one I did in New York, and the caseworker came down and handed it back to me because I applied for both my mother and my father because I didn't know what I was doing. And that's when I started taking every CLE course I could. And that was like 35 years ago. Okay. Yeah.
No, thank you so much for your presentation today and for all of your service.
I just hope you guys work this out that so that the clients are protected. And I want to say that every elder law attorney that has given you the legislature testimony and that I know of, and everyone that's been on this committee really cares about their clients. All right. So I am hoping you take that under advisement and that we all can work together. And I always say a nursing home has to get paid because where else am I going to put? I want to put my clients in good nursing homes with good staffing, right? So nursing homes have to be paid.
Thank you, Linnea. Michael, you have a question? It's 11:57.
Yeah, exactly. So I'm going to just make my concluding remarks and then I'll kick it to you to close it off, Joan. I want to really thank everyone. I'm very pleased with how this meeting went. Thank you all for coming. I thought we had some good conversation and some good opportunities to consider. I particularly appreciate Attorney Lang's return to home notice. That's something I've really been hearing about from other people too. The fact that sometimes there's an opportunity for folks to leave an institution, to return to the community, and we need to do a better job about letting them know about their rights, which leads us to the next recommendation I super appreciated, which was this concept of the Medicaid Applicants Bill of Rights. So thank you for that. I definitely also appreciated learning more about how things are done in New Jersey and comparing. So thank you to Attorney Rothkopf as well. And I'm looking forward to our next meeting, and thank you everyone for being here today. And I'll return it to you, Joan. Thank you.
Thank you. We have 2 minutes. Anybody has any last comments? If not, we can wrap it up. I appreciate everybody staying and the conversation we had today too. I think it went really well, and we do have a lot of things that we can bring forward and hopefully compile it into our report. And our next meeting is December 16th. So be on the lookout for the Zoom link for that. If
Just
nobody
real
has-
quick, it looks like, pardon me, John, I'm sorry. It just looks like, I want to make sure Michelle gets a chance to ask her question before you.
Oh, I'm sorry. I thought you were waving goodbye. I didn't see your background.
I
I can't
tend
see
to
the
do these
hand.
expressions that confuse everyone. I know I'll make this really quick, but since DSS is here, I thought it was a great opportunity to ask. And if you gave this info to us last time, I apologize. But regarding the long-term applications that come in, do you know what percentage of them are for the home care program and what are for actual skilled nursing facilities?
I may have that information. Let me go back and see if I can provide it to the group.
Okay, thank you. That's it.
Thank you. The picture that's behind you is kind of yellowish, so the little yellow hand doesn't, I couldn't see it. Where it is. I apologize. All right, I think we're good then. We'll see everybody in 2 weeks.
Thank you, everyone.
Thank you, everyone.
Thank you.